Hey there, community. You know that planning for your death and potential incapacity is important. Have you thought to yourself that you would just do it yourself online? Maybe spend $100 and check it off your list and think that you are good to go. Why would you spend $2,000 on an awesome television or couch, but then think spending $100 on a plan that is supposed to protect your kids, your spouse, the assets that you've worked your entire life to build is actually a good idea or is actually going to work for your family? Ever hear that you get what you pay for? The problem is that you don't even realize that your cheap and quick DIY plan might actually be worse than having no plan at all. Continue watching to learn why. My name is Sotera Anderson, and I am your personal legacy lawyer. I protect families and their legacies by helping them plan for the unexpected. It boggles my mind that people think it is okay to DIY these kind of documents. But let me give you some reasons why you ought not want to do it yourself. Here is an inconvenient truth. Creating a plan using online documents can give you a false sense of security. You think you've got your planning covered when you most certainly do not. DIY plans can even lead you to believe that you no longer need to worry about estate planning, causing you to put it off until it's too late. In this way, relying on DIY planning documents is one of the most dangerous choices that you can make. In the end, those generic forms could end up costing your family even more money and heartache than if you'd never gotten around to doing any planning at all. At least with no plan at all, planning would likely remain at the forefront of your mind, where it rightfully belongs, until it is handled properly. Planning to fail. Many people don't realize that estate planning entails much more than just filling out legal forms. Without a thorough understanding of how the legal process works upon your death or your incapacity, you'll likely make serious mistakes when creating a DIY plan. Even worse, these mistakes won't even be discovered until it's too late, and the loved ones you were trying to protect will be the very ones forced to clean up your mess. The whole purpose of estate planning is to keep your family out of court and out of conflict when you die or become incapacitated. Yet as cheap online estate planning services become more and more popular, millions of people are learning, or will soon learn, that taking the DIY route can not only fail to achieve its purpose, it can make the court cases and family conflicts far worse and more costly. One size does not fit all. Online planning documents may appear to save you time and money, but keep in mind, just because you created legal documents doesn't mean they're actually going to work when you need them. If you read the fine print of most do-it-yourself planning websites, you will find numerous disclaimers pointing out that their documents are no substitute for the advice of a lawyer. Some disclaimers warn that their documents are not even guaranteed to be correct, complete, or up to date. These facts should be a huge red flag, but it's just one part of the problem. Even if the forms are 100% correct and up to date, there are still many pitfalls that can cause the documents to not work as intended or fail altogether. And without an attorney to advise you, you won't have any idea of what you should or shouldn't be watching out for. Estate planning is definitely not a one-size-fits-all kind of deal. Even if you think your particular planning situation is simple, that turns out to almost never be the case. To demonstrate just how complicated the planning process can be, I'm going to give you 4 common complications you're likely to encounter with a do-it-yourself plan. 1, improper execution. To be considered legally valid, some planning documents must be executed, like, for example, signed, witnessed, notarized, following very strict legal procedures. For example, many states require that you and every witness to your will must sign it in the presence of one another. If your DIY will doesn't mention that, or you don't read the fine print and you fail to follow that procedure, the document can be worthless. Number 2, not adhering to state law. State laws are very specific about who can serve in certain roles, like a trustee, an executor, a financial power of attorney. And in some states, for instance, the executor of your will must either be a family member or an in-law, and if not, the person must live in your state. If your chosen executor doesn't meet those requirements, then he can or cannot serve for those particular states. 3, unforeseen conflict. Family dynamics are, to put it lightly, complex, and this is particularly true for blended families where you have spouses from one marriage and have children from another marriage, and do-it-yourself service cannot consider all the potential conflicts might arise for your family members and help you plan ahead to avoid it. Even when done right, the estate planning process is actually a huge opportunity to build new connections with your family, and we're specifically trained to help you with that. In fact, that's our special sauce. So, I mean, we've all seen the impact of families ripped apart due to poor planning. Yet every day we see families brought closer together as a result of handling these matters the right way. And we want that for your family. Number 4, thinking a will is enough. Lots of people that create a will think it's sufficient to handle all of their planning needs, but that's rarely the case. A will, for example, does nothing in the event of your incapacity, for which you would also need a healthcare directive and/or a living will, plus a durable financial power of attorney. So, because a will requires probate, it does nothing to keep your loved ones out of court upon your death. And if you have minor children, relying on a will alone could leave your kids vulnerable to being taken out of your home and into the care of strangers. 5, generic documents can put the people that you love the most at risk, your children. Knowing your DIY plan could fail and force your family into court and conflict is distressing enough. But imagine how you'd feel if you knew that your attempt to save money on your estate plan caused your children to be taken into the care of strangers, even temporarily. This is the part that but this is exactly what's going to happen if you rely on a generic will and other legal documents that you find online to name guardians for your kids. In fact, this could happen even if you create a plan with a lawyer who isn't trained to plan for the unique needs of parents with minor children. Naming and legally documenting guardians for your kids might seem like a fairly straightforward process, but it entails a number of complexities most people aren't even aware of. Even lawyers with decades of experience typically make at least one of 6 mistakes when naming long-term guardians. If estate plans created with the assistance of an attorney are likely to leave your children at risk, do you really think that you're going to get things right on your own using a do-it-yourself online platform? What's so complicated about naming guardians, you might be asking? Some DIY wills allow you to name legal guardians for your kids in the event of your death, and that's a good start. But does it allow you to name backup candidates in case your first choice is unavailable to serve? Does it talk about short-term guardians? If you named a married couple to serve and one of them is unavailable due to injury, death, divorce, what happens then? Would it still be okay if only one of them can serve as your child's guardian? And does it matter which one? What would happen if you became incapacitated by illness or injury and are unable to care for your kids? You might assume that the guardians named in your DIY will would actually get custody, but did you know that a will only goes into effect upon your death and does nothing to protect your kids in the event of your incapacity? Do the guardians that you've named live far from your home? And if so, how long would it take them to make it to your house to pick up your kids? A few days? A few weeks? Who would care for your kids until those guardians arrive? Did you know that without legally binding arrangements for the immediate care of your children, they are likely to be placed in child protective services until those guardians arrive? I bet the DIY online stuff doesn't tell you that. Even if you name family who live nearby as guardians, what happens if they are out of town or otherwise can't get to your kids right away? And assuming the guardians you named can immediately get to your home to pick up your kids, do they even know where your will is located? How will they prove how will they prove they're your children's guardians if they can't even find your planning documents? These are just a few of the potential complications that could arise if you try to create a plan on your own, naming legal guardians for your kids. And if just one of these contingencies were to occur, your children would more than likely be placed into the care of strangers, even if it's only for a short period of time. I want to talk about the kids' protection plan. Seeing all of the things that could go wrong, you should never trust the safety and care of your children in a do-it-yourself plan. Or for that matter, a plan created by a lawyer who's unfamiliar with the unique needs of planning for parents with minor children. To make sure that your children are never raised by someone you don't trust or taken into the custody of strangers, even temporarily, consider a kids' protection plan. The Kids Protection Plan is a comprehensive system designed specifically to address the inherent gaps in the way most estate plans document legal guardians. Consider what is at risk, what is at stake. The do-it-yourself approach might be a good idea if you're looking to build a deck for your backyard, but when it comes to estate planning, it's one of the worst choices that you can make. Are you really willing to put your family's well-being and wealth at risk just to save a few bucks? If you've yet to do your planning, I encourage you to please contact me to schedule a life and legacy planning session. This session will allow us to determine if a simple will or some other strategy, such as a living trust, is your best option. I look forward to protecting you, your family, and your legacy. See you soon.